What NASCAR did after the lawsuit was filed is truly shocking. Tout teams accused NASCAR of breaking antitrust laws, claiming that the organization controlled the sport in a way that hurt teams financially. They wanted NASCAR to be fairer, especially when it came to revenue distribution and charter agreements. The lawsuit created tension between NASCAR and these teams, and it didn't take long for the battle to escalate. On March 14, 2025, 2311 and Front Row filed their response to NASCAR's appeal of an earlier court ruling. That ruling forced NASCAR to allow both teams to race as charter teams in the 2025 season, with each having 3 charters. One of these charters was purchased in the offseason from Stewart Haas Racing. NASCAR, however, wasn't happy with the decision and took the fight to a higher court. A hearing on the appeal was scheduled for May 9, with a final decision expected weeks later, and if things moved quickly, the case could be resolved by the end of the year, but everyone knew there was a chance the legal battle could drag into 2026. One of the biggest arguments in this lawsuit was whether NASCAR had too much control over the Cup Series. The teams claimed that NASCAR made it impossible for them to succeed financially because of the way it structured its business model. NASCAR, on the other hand, argued that it was simply running the sport like any other major organizations. The teams also said that without the injunction, they wouldn't be able to compete at the level needed to stay in the Cup Series. They pointed out that the current charter agreement didn't give them the financial support necessary to be competitive. NASCAR saw things differently. In early March, it fought back with a counterclaim, accusing 2311 and Front Row of using unfair tactics during negotiations. NASCAR said that Curtis Polk, co-owner of 2311 and longtime business manager for Michael Jordan, tried to organize a boycott of a required team meeting. He also allegedly attempted to convince teams to skip a qualifying event, although that boycott never happened. NASCAR argued that these actions were illegal and designed to pressure it into giving the teams better financial terms. The counterclaim was a major moment in the case because it allowed NASCAR to publicly defend itself. Before this, the organization had been mostly silent, letting court documents do the talking. But now, NASCAR's lead attorney, Chris Yates, spoke openly. He claimed that 2311 and Front Row were twisting antitrust laws to force NASCAR into renegotiating a deal that most teams had already accepted. He made it clear that NASCAR had no interest in making changes, stating that 13 out of 15 race organizations, which controlled 32 of the 36 charters, had already agreed to the new deal. That new charter agreement was set to last from 2025 to 2031, with a possible 7-year extension. It also significantly increased how much money teams would get. Under the previous deal, teams received around 38 to 40% of the revenue for media rights. In the new agreement, that number was raised to 49%. NASCAR saw this as proof that the teams had a solid financial model, but with 2311 and Front Row argued that even with the increase, it wasn't enough to make running a team profitable. Despite NASCAR's strong stance, the teams didn't back down. Their attorney, Jeffrey Kessler, called NASCAR's counterclaim a meritless distraction. He said the lawsuit was about making NASCAR more competitive and fair for teams, drivers, sponsors, and fans. He pointed out that other major sports had gone through similar legal battles and that this was NASCAR's time for change. He also believed the teams had a strong case and would prove it in court. Back in February, NASCAR had already started fighting the lawsuit by filing an appeal to the injunction. The appeal focused on one key argument. NASCAR Cup Series racing couldn't be considered its own market in an antitrust case. NASCAR said that if teams didn't like the charter agreement, they could race elsewhere. It insisted that NASCAR wasn't a monopoly and that it was simply running a business like any other sports organization. The legal fight had actually started even earlier, in January, when NASCAR tried to get the case dismissed entirely. But the judge denied the motion. He believed the case needed to go to trial because it wasn't yet clear whether NASCAR had violated antitrust laws. He also set a date for the trial, December 1st, 2025. Judge Bell's ruling was a blow to NASCAR. It meant the case would move forward and both sides would have to present evidence. He also refused to require the teams to post a bond for the earnings they received while the case was ongoing. This was important because if 2311 and Front Row lost the case, they wouldn't have to immediately pay back any money they made during the lawsuit. The judge also made another important ruling. NASCAR had to allow 2311 and Front Row to race with 3 charters each in 2025. NASCAR had originally offered them only 2 charters each, but the teams didn't sign those agreements because of a clause that released NASCAR from legal claims. Instead, they bought additional charters from Stewart-Haas Racing. The judge ruled that NASCAR had to approve those transactions, which was a victory for the teams. Despite these legal battles, NASCAR still had a sport to run. The 2025 season was approaching fast, and teams were preparing their cars and drivers for another year of competition. But the lawsuit created uncertainty about the future of the Cup Series. If 2311 and Front Row won, it could change the way teams in NASCAR work together. If NASCAR won, it would strengthen its control over the sport. On January 8, a U.S. District Court held a hearing on NASCAR's motion to dismiss the case. The judge heard arguments from both sides but did not immediately rule. He indicated that the case deserved to go to trial within the year. NASCAR's argument for dismissal was that the claims made by the teams did not prove any legal violations. However, the judge's comments suggested that the case would likely move forward rather than being dismissed. For NASCAR to get the case successfully thrown out, it had to prove that even if all the team's claims were true, no laws had been broken. This was a high bar to meet, especially given the complexity of antitrust law. NASCAR argued that Cup Series racing was too small a market to be considered under antitrust laws, and that its actions had not been anti-competitive. It pointed out that it had increased the percentage of TV revenue given to teams in the 2025 charter agreement, but the teams argued that NASCAR's actions harmed competition and limited their ability to operate fairly. Meanwhile, Judge Bell issued 2 injunctions, requiring NASCAR to allow 2311 and FRM to race as charter organizations in 2025. This meant that despite the ongoing lawsuit, the teams were guaranteed to compete under the charter system using the additional charters they had purchased. NASCAR was appealing this ruling, but no date had been set for when the appeal would be heard. A few weeks earlier, on December 23rd, NASCAR was ordered to approve one of the Stewart-Haas Racing charters for FRM. However, the judge ruled that 2311 Racing would need to file a separate motion for its charter purchase to be approved. This legal process was necessary because at the time of the injunction request, 2311 had not yet received a formal denial from NASCAR. The teams argued that NASCAR had initially approved the charter transfers, but later changed its position in retaliation for the lawsuit. This, they claimed, was an example of NASCAR acting anti-competitively. On December 2nd, NASCAR officially filed a motion to dismiss the case. It argued that the team's complaints were simply about not getting what they wanted in the 2025 charter agreement. NASCAR also pointed out that most of the alleged anti-competitive actions occurred more than 4 years ago, exceeding the statute of limitations for antitrust claims. It further argued that because most Cup Series teams had signed the 2025 agreement, this showed that the system was not monopolistic. On November 26, the teams filed a renewed motion for a preliminary injunction, citing new evidence. Although some details were redacted from public documents, they claimed that their sponsors needed guarantees that they would be charter teams in 2025. They also requested permission to purchase Stewart-Haas Racing charters without being forced to waive their right to sue NASCAR. Earlier in November, the teams had dropped an appeal related to a previous injunction denial. They stated that new circumstances had removed the need for the appeal and that they would seek new legal relief. This signaled their intention to continue fighting for their charters while keeping their lawsuit against NASCAR active. By November 16th, NASCAR had provided 2311 Racing and FRM with open team agreements, allowing them to compete in 2025 even without charters. However, the teams still wanted charters as open teams received significantly less revenue and were not guaranteed entry into every race. They asked the U.S. Court of Appeals to speed up the timeline for ruling on their request for an injunction. They wanted a hearing in December rather than waiting until March, arguing that waiting too long would impact their ability to compete effectively. Now, the next big moment in the case would come in May, when the U.S. Court of Appeals would hear NASCAR's appeal, and if the court ruled in NASCAR's favor, it could weaken the team's position. And that's all we have for today's episode. Don't forget to give you a like, smash that subscribe button, and also ring that notification bell for more upcoming videos.